The topic of our next two classes is negligence. This is one of the largest areas of the law, and it's complicated, it's robust, it's also very interesting. You've heard the term negligence, you've probably used it, you probably didn't really know much about what it meant in a legal sense, but it's incredibly important. Most of the lawsuits that you hear about that you or your employer or your family are at risk for are negligence lawsuits. When you have traffic accidents and people are suing in civil court, it's because you were negligent. If somebody gets hurt, slips and falls at your business, it's an allegation of negligence. These things happen all the time. The McDonald's hot coffee case is an allegation of negligence. So it is probably one of our largest umbrellas for legal issues that arise, and that means it's also one of the areas where we want to protect ourselves and our ideas and our companies. So one of the things we're going to focus on here is that how do we protect ourselves, how do we protect our companies from being negligent? And one thing we'll do today is I'm not going to speak to you directly a lot. I'm going to actually put on some slides because I've got a lot of images, and we're going to look at some warning labels. We're going to look at a lot of diagrams and tell some stories on how to understand and appreciate this idea of negligence. But there are four main elements, okay? And these are going to be important because when you take the exam in this class, you need to know the four main elements and know a lot about them. Each one will be its own issue, rule, analysis, conclusion. Those four main elements of negligence are duty, breach, causation, and damages. To find negligence, you must have all four of them. There must be a duty of care. That duty of care must be breached. There must be a direct correlation and causation, and then there must be some kind of damage created. We're going to talk at length about each of those, and we're going to start with understanding what a duty of care is. So here we go. We're going to take a very entry-level dive into negligence, but it's an interesting topic. All right, hi everyone. We are going to talk about negligence now, and this portion of the lecture will really be where we cover the meat of today's lecture material. You're going to have a couple cases that I'm talking about in separate videos, and they will be illustrations of points in here, but really this is where we're going to cover the most ground and what you need to know about some of the basic components of negligence. I would encourage you to hit pause, skip back and listen again if we're going a little bit fast, but you're going to want to take some notes, and I think one of the great things about doing this on YouTube is that you have the ability to pause it and break it. So here we go. Let's jump right in now. We've already talked about a little bit on the elements of negligence. There are four main elements: the duty of care, the breach of that duty. Then we establish that there's causation. We have two concepts in causation: actual and proximate. We'll get to those in a few minutes. And then there's damages. We must always have damages. So you have to satisfy all four of these major categories in order to have negligence. If one of them fails, then there's not a negligence cause of action. So we have to go through each of them. And again, on the exam, as I've said before, on the exam, I will be expecting an issue, rule, analysis, conclusion, IRAC for each of these four elements. So let's spend a little bit of time on the duty of care. By definition, we owe a duty of care to those who would be foreseeably at risk of harm. So I want you to think about really a sphere around you at all times, or around your business. And the people who who intersect with that sphere are foreseeably at risk. So think about driving your car, right? You could hit pedestrians on the sidewalk. You could hit bicyclists who are sharing the road. You could hit other drivers if you're not paying attention, right? So all of these people are within your duty of care. You owe them a duty, like a responsibility. You owe them the responsibility to be careful because they are foreseeably at risk of harm. And so when you get on the road, you are putting yourself in a situation where you could be liable for negligence if you do not show those who would be foreseeably at risk of harm this duty of care. So when you don't drive safely, you are putting them at risk. The operable word here is foreseeable. Who do we imagine, and not, this isn't, far out, we're not talking about, really stretching the imagination here. Who's really, in this sphere that there is a real chance of them getting hurt? Okay. So driving, think about just, when you're going through your daily life too, you are constantly putting people, constantly coming into contact with people who could be foreseeably at risk of you causing them harm. So think about you're just walking through the hallway, you're texting, right? You run into someone who spills hot coffee on themselves. I mean, that's a foreseeable thing. We could imagine that happening. You trip over someone's bag and step on their laptop that's in the bag, right? You're texting and walking. You owe a duty of care to people around you, and if you're texting and walking, you are foreseeably putting them at risk of harm of you not seeing them or their belongings. I also want to talk about products, because if you own a business, you're thinking constantly about the people you are foreseeably putting at risk of harm for your products. So we can imagine, get back to the car example, right? We can imagine the car companies thinking about when they add features to artificial intelligence driving your car, right? They are thinking about negligent situations. Who is foreseeably at risk of harm? What do we do with pedestrians? What do we do with bicyclists? What do we do with dogs? What do we do with oncoming traffic? So constantly running this legal idea of negligence through their mechanisms to make decisions. At Bedford, we are thinking about things like our inks. Are our inks, are we using them in situations where they could rub off onto edible products? Are they food grade? If not, are they coming into potential contact with a situation where people could consume them? So there's something we see, is there a foreseeable risk of harm, or is there a barrier between our ink and what someone can come into contact with? So for instance, a twist tie on a bread bag is, if we used an ink that had some kind of dangerous substance in it, right? Or at least something you wouldn't want to consume, okay? Is there a risk is it foreseeable that tie could come into contact with the bread? Well, there should always be a plastic bag between the tie and the bread, but it's foreseeable that it's on the counter, and you take the twist out, set on the counter, you set your bread to spread it, and the bread and the tie come into contact. It's foreseeable. How is it? Is it too far beyond beyond the scope of what's reasonably foreseeable? I don't know. I think I could make an argument either way. It's something that we certainly, as a business, are cautious of, and we consider it a foreseeable risk. So that's something that each business has to decide, because there's not a bright line rule for what is foreseeable and what isn't. Let's look at a couple examples of this. This is why this foreseeability of risk is why you see all of these warning labels on products. So here's one for Vidal Sassoon hair dryer. Do not use while sleeping. Seems ridiculous, but there is a TLC show on My Strange Addiction, and one of the episodes is about a woman that sleeps with her hair dryer because she likes the noise, the white noise sound, and she likes the heat, and so she puts it in her bed with her. And once you see these things happen, it now becomes a foreseeable risk, because people might copy it, or of a certain subset of people that do this. Okay. Do not put any person, here's one for a clothes washer, do not put any person in this washer. I don't know why you would do this, but I suppose it's been done, and there's some reason that they would waste money, so to speak, on this, or they would not waste it if they didn't think there was a foreseeable risk. Warning, these globes should not be referred to for navigation. Now, I don't know why you'd trust navigating one of these, but I suppose there was a time and place before GPS when you had, when you would go sailing and you would have a globe in your sailboat and you'd be trying to sail to Easter Island and you might get off course. So they want to make it clear that this is not to scale, and they don't want to be held responsible for anyone who might try to rely on the detail of that map. Caution, griddle surface may be hot during and after cooking. Who wouldn't expect this to be hot? But there are surfaces like induction heaters that don't get hot, and so and you can't. It certainly doesn't get red like you would expect. I mean, this is probably probably the main driver is that you're used to stoves that get red hot, and this won't. And so I suppose you want to warn, because you can imagine people touching it. You can imagine people just bumping this, or they put their arm on it, their hand on it, and they get a serious burn, and so they just decide they're going to sue the company because they're angry about it. And so even though people should know this, you are just warning of this so that you have a good argument in court that you did warn about it. Finally, we have this one, warning, do not drink, for this Epson printer ink. Hard to imagine this, but kids these days, they're trying to drink anything to get a little buzz, so I suppose they might try some printer ink. Who knows, but we don't want people to do it, and so they put a warning on it. So what is the standard for this duty of care? What does it actually mean? So we judge your actions by the reasonably prudent person. So we say each person must act as a reasonably prudent person would act. Or each business must act as a reasonably prudent business. And so you have to act like you have to do what a prudent person would do in this situation. So a prudent person, for instance, would not walk and text. A prudent person would drive safely without looking at their phone, without being distracted or being too tired. A prudent company would put warnings on that say, do not drink this printer ink, do not touch this griddle when it's hot. So if you don't do these things, we are saying you are not doing what a reasonably prudent person would do, and then you are potentially at risk for negligence. So I want to give you an example of someone that I think you could use as a mental image for who the reasonably prudent person would be, and that is Professor Bruce Olson. Take a look at this guy, right? I mean, he wears this, this baggy sweater. So if you spill something on it, pretty easy to clean it up, hide it. He's got the like hiking pants that are like low wrinkle. You don't have to iron them. He's got the nice sturdy keen hiking boots to get around in a Minnesota winter. So think about what Bruce Olson would do. He's like your reasonably prudent person. He's thoughtful, and he thinks about his actions before he does them. He's not too crazy. He's not going to get out of hand. He took some time before deciding if he wanted to get a smartphone. He's not just jumping at the latest trends. So you got this reasonably prudent person, okay? So think about him. Bruce Olson is not someone who would bring in an airsoft gun into the hallway, right? Because somebody might take an eye out with this thing. So think about what Bruce Olson would and wouldn't do. He is our example of a reasonably prudent person for today. If Bruce Olson wouldn't do it, then you're probably there's going to be some question about whether it's a negligence situation. So now this is a bit situational, right? Because the reasonably prudent person gets put into situations that don't always seem to be, well, frankly, don't necessarily seem to be all that prudent sometimes, right? Let's say, for instance, that Bruce Olson inherited a bungee jumping company. Now, I don't think Bruce Olson has been bungee jumping. Maybe I'm wrong. I don't think he probably would. But if he inherited a bungee jumping company, he would say, well, I am going to do this to the highest safety standard. I'm going to get every safety certification possible. I am going to make sure all of the equipment is up to date and is checked, and that all of our instructors are trained and that they're getting regular certifications, and that we're making sure we have the best insurance, and that he would do his best to make sure no one gets hurt. So he is operating a bungee jumping company as a reasonably prudent person would operate it. And if you have a bungee jumping company and you decide to let the equipment, go a little longer than its life, or you decide not to hold, insurance, and maybe you decide to have people who aren't really trained in proper bungee jumping management run your operation. Well, now suddenly you're not operating like a reasonably prudent person, and you are at risk for a negligence lawsuit if someone gets injured. So, different example for you. What makes for a reasonably prudent university when it comes to safety? Now, at a university I previously worked at, they had posts like the one in this picture that had a camera, and it had a button where you could run up. If you had an emergency, you could run up, hit the button, the light would start flashing, the camera would, was already going, but it would become the main video in the security office, and you could actually talk to a security person. So if you had something happen in the parking lot, you could run up and do this. Now, I know at least at Bethel, when I was a student, this was back in the days of CDs, and everyone, well, not everyone, but a lot of people had these giant books of CDs. They were these massive cases, and you would just fill them. I mean, you could have like 100 and some CDs in these books, and we're not going to take them inside of your dorm every time. So you'd leave them in your car, but people would come from across Snelling. They would sneak in through the woods, and they would smash car windows to steal all of the CDs. Pretty ridiculous. It actually happened a lot. I mean, there were weeks, especially during the first couple weeks of school, when you had people arriving who didn't know about this. It would happen every couple nights, and it was really hard for security to track down. But if they had cameras in the parking lot, like this post that we're looking at, certainly would have been better. If someone was out in the parking lot and they got into a situation that seemed dangerous, you could run up to this post. So if something happened on Bethel's campus and they don't have these posts, would Bethel be seen as acting reasonably prudent, or for not having them? Would they be at risk for a negligence cause of action? I'd love to hear what you think. Obviously, we can't chat about this, but when I've talked in class about the situation before, most students are saying, I don't think Bethel has to have them, and if something happened in a parking lot, I don't think Bethel would be is being unreasonable for not having them. So that's fair. I don't see them on a lot of campuses. I've seen them on only one that I've worked on. They're probably on more, but it's certainly not everywhere. So, it's not something that Bethel is overlooking that every school should have. I think Bethel could do more in this department. These would be a nice feature, but probably a reasonably prudent university does not have to have these emergency posts. So now, if suddenly Northwestern, St. Paul, and St. Olaf, and Carleton, and St. John's all installed these, and so you have all these MIAC schools and local schools in the Minneapolis area that have these posts, and Bethel is the only one that doesn't have them, and something happens at Bethel's campus. I think that changes your reasonably prudent person standards. So you see how it kind of changes based upon what everyone else is thinking, right? Because all the other universities have now, at least a majority of them, have decided that they need to have these. So it suddenly becomes the new reasonably prudent university standard is to have these emergency posts. So it's a standard that changes based upon, in some degree, based upon your peers. Bethel's got these cars, the security cars that run through campus, and in my view, they don't do a lot, right? I mean, they patrol, they drive around, but it's not like, it'd be rare that you have an emergency that happens right where the car is at, right? And so the car can just pull up. It's rare that they're catching people doing things, but I think they do. But if you're doing something on campus that's getting into a little bit of trouble, you're probably watching for the cars, and so you're avoiding them. So why do we even have them? I mean, and I think that the answer is a reasonably prudent university right now has to have the minimum standard. The reasonably prudent standard is to have a patrol car that patrols, every 20 minutes or half an hour or hour. Certainly, if Bethel had absolute safety in mind, they would have an army of patrol cars patrolling all the time, and they'd have these posts everywhere. But they don't. The statistics on how often they patrol, I mean, just it tells you that they can't be everywhere that potential incidents could be. So they're really, again, the chance that they're gonna catch something is pretty low. So really, its purpose is simply to meet the liability standard that if an incident happens on campus, Bethel can't be sued and say, well, you should have had a patrol car because you could have responded more quickly. Now, I think Bethel still has the best intentions in mind, but when we get down to it, they're doing whatever the reasonably prudent university has to do and nothing more, or at least not much more. And so that's the standard that we'd look to in a lawsuit if an incident happened on campus. One more example for you here, and how the standard changes is that there was someone I knew in high school who raced motocross. He fell while he was racing. When he fell, he cut off the tip of his finger on metal that was sticking up, a piece of sharp metal that was sticking up through the jump, and had to go and have this finger sewn back on. Well, what they found out is that the person who built this motocross track had just taken old junk, cars and things, and buried them so you didn't have to have as much dirt under the jumps and to build them up, and sort of took a shortcut, right? And so that ended up, the metal ended up getting uncovered in the course of the race, and that's what cut his finger off. Motocross is a very dangerous activity, so you have to do it. You have to do it to the degree that it can be done safely. And again, this is a highly dangerous activity, but the reasonably prudent motocross track builder would build their jumps out of dirt, would not bury metal components or rusted out old cars under the jumps to build them up. And so again, this is how the standard is sort of. I don't race motocross. I would probably break several limbs, and so to me, it's at least it's a dangerous activity. It looks like fun, but you can do this as a reasonably prudent motocross rider and a track builder, but you do have to do things. There are still foreseeable risks, but those risks and change and expand given the circumstances. We've talked a little bit about the reasonably prudent person standard, right? What does it mean to have a breach? So we compare the defendant's actions to the reasonably prudent person. If these two things do not meet, we have a breach. Okay? If Bethel refused to have patrol cars on its campus, and an incident took place that someone got, injured or assaulted or something, Bethel's actions would not meet the reasonably prudent university. The reasonably prudent motocross track builder builds their jumps out of dirt. And when you build them out of something other than dirt, that there are metal parts under it, you're not rising to that to that reasonably prudent person standard. Okay, so that is a breach. Again, we compare the defendant's actions to the reasonably prudent person. If these two things do not meet up, we have a breach. Now you want to focus on the behavior here and not the mental state, not intent. So, and most of the time, people don't intend things to happen, right? Especially in negligence, you're not intending to step on someone's laptop when you're walking and texting. You're not intending to get into a car accident when you are looking at your phone. But you do, right? Because you're looking at your phone, and so you crash into somebody or you step on their laptop, whatever happens. That's what a breach looks like. The Curry versus Chevron case is really going to look, that we'll be discussing in a minute in a separate video, is really going to look at this idea of breach. So does the clerk in a gas station, does their actions on behalf of their business rise to the reasonably prudent standard? And if they don't, then Chevron, as an employer, based on the actions of its employee, has breached the duty of care. Okay. Before we get to that, a couple other things I want you to think about. And I want to put this in some context to Bethel. You know, Bethel has a duty of care to its students. It has a duty to think ahead about foreseeable risks. So I'll give you a couple situations. Does Bethel have the duty to keep Kresge Courtyard free of potholes? Yeah, I think so, right? Because if the pothole develops, you can imagine that people are walking and they're talking. These are students. Maybe they're walking and texting. They probably are. It's foreseeable. And you're not necessarily looking at, because you're on the sidewalk, you're expecting there to not be any potholes. So if you fall in a pothole and trip and break a leg, Bethel is probably responsible. Is Bethel responsible for, ice that builds up on those trails, on those paths through Kresge Courtyard? Yeah, if people slip on ice on your property and you didn't do anything about it, you're responsible. So that's why we're out putting salt on. Now, if this happens at 4 in the morning and there's an ice storm that started at 2 in the morning and someone's running through the courtyard and slips and falls, that's probably, a reasonably prudent place of business would not be able to get out there at 4 in the morning. But 8 a.m., 8:30, 9, absolutely, you should have ice first thing in the morning. So, that's why we go out and we put ice. We go out and we clear the sidewalks and we try to get on those things right away within at least a reasonable amount of time. Does Bethel have a duty, if you've ever been through the woods, you've been down by the lake, does Bethel have a duty to keep its woods clear of brush and fallen trees? I think certainly in the places where it has designated as trails, even if they are off-road trails, Bethel has to go out and clear those and remove any obstructions that could cause injury. Now, if you're running through the woods off trail, I don't think that they have to keep clear. That's too much to ask. So again, part of this is where are we foreseeing people to go? Now, are students going to go in the woods? Sure. I've been run through random parts of the woods to see what's back there, and you're on this campus and you're a freshman, you don't have a car, and so you're like, let's see what's in here, right? But it's a very difficult thing, and certainly if you are deciding to go into the woods, you are you're assuming some of that risk. But I think Bethel has, but it's not an absolute risk. If Bethel is leaving, rolls of barbed wire back there, that's probably borderline too risky, and they should be removing those things if they know that they're there. Some of you may have heard that there were at least an access point to the sewers of Arden Hills that spills out onto campus, and you get to go kind of play Ninja Turtles. At least when I was a student, these were open. They've subsequently, we'll get to this in a minute, but they put some locked bars across the entrance to this sewer system. But you could go in the storm sewer And when I was a student, we took the storm sewers all the way over to Perkins, came up through a manhole, again, totally Ninja Turtle style, came up through a manhole, went to Perkins, and you're like crawling through, like there are all these different tunnels going different places. And I heard about people who went all the way over to Target, came up in the Target parking lot. But does Bethel have a duty to keep students from going into the sewers? Probably, and for many years they didn't. And if someone would have gotten hurt in there, Bethel probably would have been liable, because it is foreseeable that, and indeed students did regularly go into the sewers, and I believe if somebody would have gotten hurt, they could have been held responsible, and subsequently, in recent years, they have closed them and locked them. And so, as an example of Bethel, wising up to what a reasonable university should do. Duty of care and breach of the duty of care. These are the two big topics. This is where you're going to have really the meat of your discussion on the exam and thinking about these questions. We're going to deal with causation and damages in the next video. They will not take us quite as long to cover, but there's a lot to discuss there too, particularly in proximate causation, but we'll get to that in a minute. So I hope this makes some sense today. I know we had a lot of information to cover. We're covering it pretty fast. Again, I'd recommend you, if you want to listen to this again, it might make some more sense, and we will make sure we get everything straightened out and clear and coherent for the midterm exam coming up in a couple weeks. So thanks.